Thanks, everyone. Please be seated. We are now ready for the oral argument in the case of Robinson versus Central Iowa Power Cooperative and others. Looks like counsel is ready. Mr. Geerdes, am I pronouncing it correct?
Yes.
Thank you. You may proceed.
Good morning. May it please the court, gentlemen. My name is Gregg Geerdes. I'm representing the Robinson family, which, as we get into the facts, are uphill property owners. They own land which is across a public road and uphill from land which is owned by SIPCO. This is a drainage case. It's easy, I think, to now overlook the importance of drainage cases to Iowa farmland, primarily because it's all been buried underground. There's approximately 14 million acres of tiled farmland in Iowa, and you can't see the tile, so it's easy to drive down the road and not pay much attention to it, but it is as important now as it was back in 1900, where everything north of present Highway 30 was largely a swamp in this state, and it's because of tile that it no longer is. We're talking about what the rights of an uphill farmland owner are, and for well over a century, the Iowa legislature and this court have adopted numerous statutes and case law decisions which provide that the uphill farm owner has a legal and natural easement to run tile across a natural water course in his downhill neighbor's property. Now, it didn't take very long after the statute was passed before this court started analyzing the rights and obligations of the parties as being dominant and a servient easement. And it didn't take very long for this court to specify where that easement exists. In the Heinze case, I'll quote this: "The dominant estate," that's the uphill owner, "has an easement of drainage through the natural water course across the servient estate, and the owner of the servient estate has no right to prevent by artificial means the flow of surface water through the natural water course from the dominant estate."
Well, the thing that you just quoted talks about surface water, and what we're talking about is tile.
Does a good job of discussing that issue in his law review. He notes, and the case law supports, that there is no difference between the way subsurface surface water, which is tile, and surface water are treated. Indeed, this court has noted that that water comes from the same place. It's snowmelt, or it is rain, and it is collected in these natural water courses. And this court has specifically held that a natural water course in the Cundiff case can be tiled. And it is also held that this natural water course need not be an existing stream or something that has formal banks or is a even recognizable water course. It is defined as being where the water naturally runs. And in this case, we've got a topographical map. We've got...
Can you read that quotation from that case again?
Heinze case. The dominant estate has an easement of drainage through the natural water course across the servient estate, and the owner of the servient estate has no right to prevent, by artificial means, the flow of surface water through the natural water course from the dominant estate.
I read that is there is an easement right to have water go from the dominant estate to the servient estate through the natural water course. But once it's kind of crossed that boundary, it's really up to the servient estate how they discharge or deal with the water, so long as it doesn't cause damage to or obstruct or cause flooding on the dominant estate. Why would the dominant estate have the right to dictate how the servient estate manages the water through that property?
Schemes going on here. There is the common law scheme, which requires that there be damage to the uphill estate in order for the uphill estate to have a cause of action. And then there's the statutory scheme, which says that if you've got an existing tile, it can't be damaged or injured or impaired or diverted. Again, Professor Hamilton does a good job of distinguishing between the common law rights and the statutory scheme. The statutory scheme doesn't change the dominant-servient relationship. It just provides extra protection for the investments that have been made in tile.
Switch to the statute, and I agree that the statutory language is fairly broad, and I'll be asking the other side about it, but this language about you can't divert, obstruct, impede, or fill up any ditch, drain, or water course. But that language seems to me it's not crystal clear, and maybe it could be interpreted as just reading along the lines that Justice McDonald indicated, that you can, it doesn't mean that whatever tiling line is on that property is going to be the line, for till the end of time, that the owner of the servient estate can move it around as long as they don't affect anything having to do with your client's property.
I think that it's unambiguous. I think that you're right, that it covers any sort of impairment to tile. But I would also point out that the legislature has told us how that statute is to be interpreted. And they have told us in the statutory scheme that it is to be interpreted liberally in favor of the uphill tenant to promote damage, to promote drainage. And, that's what you got to do. For example, here, we've got 200 feet of tile that previously ran in a direct line across SIPCO's property, which they ordered destroyed and filled up. So now we've got this non-working 200 feet of tile. And what they did instead is they diverted the tile 100 feet up and then 200 feet over and then 100 feet down. So instead of having 200 feet of nice, level, downward sloping tile, we now have this zigzag arrangement, which takes things well out of the natural water course, well out of the course of natural drainage.
If it doesn't affect the water flow, I mean, I understand your clients don't like the project that's planned, but, it should have nothing to do with it, it seems to me. The question should be, the water flow issue, right?
Let me point to the record as to what actually happened. After this tile was destroyed, they didn't tell anybody, okay? They didn't tell us. What they did is they cobbled together this alternative route, which was proven by their own engineer, demonstrated by their own engineer, to not be effective in draining the property. It was some 50% less capacity than what previously existed. And you can see why when you take water out of a straight line and try to make it go somewhere where it doesn't want to go, then you're going to have difficulties.
Clarify the scope of your concern, though. You describe it as a non-working system that they've put in, and you talk about why, because they've diverted. But It seems like there's some dispute about that. And it does also seem to me that through technology, one might be able to achieve results that do provide equal drainage to what the original course would have been. And so if it did provide equal drainage, would we be here?
I think we should be here. And let me tell you, when you read the cases, I can tell you what the legislature had in mind for what they ordered and for what this court did. First of all, the reason for the straight natural course is because it is more efficient.
Pushing back on that, my hypothetical is, I mean, technology and all these sorts of options come up. Is there, in your view, is there just never going to be a situation in which they could be equaled?
I would point this court to 2008, when we were all believers in the fact that engineers could make water go where they wanted it to go. And I think we all learned the hard way that when you try to make water go where it doesn't want to go, you are inviting trouble.
Back to my earlier question, I had asked you about if there's no damage, why do we care? And you distinguish between a common law regime and a statutory regime. Do you agree that under the common law regime, if there's no damage or effect on the dominant estate, then there's no issue?
Common law scheme, an element of recovery is damage to the uphill landowner.
So your argument about the right to control the path of water flow on the Servian estate is a statutory argument, not a common law argument.
Or that's what the statute says, yes.
Case then where you have, let's say, 3 properties on a hill, who gets to control where the water flows on the 3rd property?
Reasons why the legislature chose the specific statutory language, natural course of drainage. That avoids disputes, okay? That provides certainty. In this case, SIPCO wanted to zigzag the tile up to the west. The next guy after SIPCO might want to zigzag it to the left. And the guy below him may want it to go back and forth, up and down and over the river to Grandma's house. When you do that,
We care.
this is a preventative statute. It's like a speed limit. The Iowa legislature says that I can't go more than 70 miles per hour on its interstate. They've made that determination. They made the determination here as to what is best for Iowa's drainage. Now, when I go to South Dakota, I can drive 80. But here, the Iowa legislature has entered a quite elaborate statutory scheme. And if you follow that scheme, it's required that it be in the general course of natural drainage. Indeed, when you consider the relatively recent case as far as drainage law is concerned, the relatively recent O'Toole versus Hathaway, the idea that a uphill owner can utilize the natural flow has become what this court calls a legal doctrine.
I'm looking through my notes. Which statutory provision do you think indicates that nobody has the right to move a tile line?
I don't have the statutory number in front of me, but you have to look at the sections which state that diverting or injuring or impairing or filling up a tile is a nuisance.
Being the key word.
Injury is one of the things. Impairment is one of the things. But what they've done is they've said that if you're going to fill up a tile, or if you're going to divert a tile, it is per se illegal.
Doesn't the water come in the same spot and go out the same spot?
Cases say that the easement doesn't start and stop. The easement follows the natural water course. And I would also point out that this is at a summary judgment point, and even if that argument were to be correct, there would still be a factual dispute over whether or not this rerouted tile is an equivalent, primarily because it wasn't built according to our own engineers, into SIPCO's own engineers' advice.
Let me ask you this.
Out of time, but please.
68148 speaks of the amount of damages sustained by your client. And I understand that your concept of damages was about how well your land was drained. It was about that the crops weren't doing as well because they weren't being drained. Is that right?
That's certainly part of it, but there has been a documented decline in crop yields, yes.
So that's all has to do with the ability of water to move off of your land and go elsewhere. And so if they had constructed an alternative way for the water to go, let's say it's 6 inches away from where you think it ought to go, but it's just as good, and your drainage was just as good as it had been before, there'd be no damages, correct?
Natural flow of drainage, which the natural flow of drainage is not a pencil-thin line. It's a route. It's a waterway, and you could certainly fit 2 pipes into the natural flow of drainage. You can't go 100 feet uphill like was done here. And the other thing that I would say is that tile is not just about moving water. It's about conserving the soil. It's about preserving groundwater, and there are other issues that go on with this.
Thank you. Mr. Gamez or Mr. Moreland? Who first? Mr. Gamez.
May it please the court, counsel. My name is Paul Gamez, and together with my colleague Nicholas Peterson, we are here on behalf of Central Iowa Power Cooperative and Coggin Solar LLC. We are asking on behalf of the appellees to affirm the various rulings and orders and judgments entered in the district court below that are challenged here in this case, including 2 rulings on motions for partial summary judgment, a judgment quieting title, and an award of attorney's fees. I want to begin with the central point that was made in opening argument by the appellants here, and that is whether and to what extent a dominant estate can dictate that its surface water that goes across the servient estate has to follow a prescribed route. We submit to this court that there is no authority that supports that in the state of Iowa. It's contrary to the facts of the case. It's contrary to the principles that apply to easements in Iowa.
Says you can't divert a ditch, drain, or water course. Didn't your clients divert it?
What we did is, Your Honor, and I agree, there was discussion during appellant's argument about maybe the statute isn't that clear, and it talks about diversion. We believe that that's different than rerouting underground tiling pipe, and that's what the district court concluded in this case. In the drainage area, what you typically are looking for in the cases is the water being diverted onto adjoining land? Is it being diverted away from the waterway where it ultimately ends up? None of that is happening here. This is a closed system, and it's been a closed system since the 1960s. What happens with this system is the rain comes down on the Robinson's land. They have a tiling system. It goes into their tiling system. There's an outlet from that that goes under Lynn Delaware Road, has for decades. Same inlet, same outlet, in a closed system. There is no diverting the water into adjoining land. There is no taking the water out of Heaton's Creek, where it ultimately ends up. And so we would submit, Your Honor, that the statute, as the district court found, can't be stretched so far as to say that you cannot reroute underground tiling, that all tiling in the state of Iowa that's in place today can never be moved, that's an impermissible stretch of the language in that statute.
Interpret the statute to mean, when it talks about diversion, what I think it means is at the point of the property line, you can't, as the serving estate, you have an obligation to take that water. But you can't erect a boundary or some sort of barrier at the property line and push it back onto the dominant estate or reroute it into some other property. That's how I would interpret it, is that once it's coming onto your property, you can do whatever you want as long as it's not damaging the dominant estate.
I believe, Your Honor, that that's the reasonable interpretation of what the statute means. And most importantly, that's consistent with what we believe is the common law case that controls this case, which is Logston. And in Logston, as a 1948 decision of this court, the issue was as follows. There was a stream from the dominant estate, went through a culvert onto the defendant's land, or the predecessor in interest to that land. And with regard to that water coming on to the servient estate, this is what the Iowa Supreme Court stated at that time and what we believe is the law still today. Of course, defendants can turn the water that comes through the culvert in any manner they see fit on their own land. They do not need to let the water spread out over their land. They can turn it into ditches on their land and divert the flow of water around rather than across the 10 acres, so long as they do not cast it upon the lands of adjoining owners or interfere with the rights of riparian owners. And the court in that case went on to say, because the issue was that the defendant or the predecessor in interest to the defendant had constructed a diversion ditch. They didn't want this surface water to go generally over their 10 acres. So there was a man-made ditch, and over time it filled up. And the plaintiff came along and said, wait a minute, you need to maintain that ditch. And they didn't want to. Therein lied the dispute, and the court said to the defendant about the diversion ditch, defendants took title to their land burdened with the water that flowed onto it from the culvert. They could choose to use the conversion ditch previously constructed, or they could eliminate it and avoid the work of maintaining it and let the water flow southwest across their land. So I do believe that that's the law in Iowa when it comes to the way that surface water is handled here. That's the way it's been handled with this system for decades.
Of your opponent's point that the natural course that was pre-existing is the optimal course, and that the alternative process that your client has constructed, it's just not doing as well.
I don't think that Your Honor, we don't believe that the facts support that. In fact, one of the big issues in this case was whether or not the appellants had suffered any damage, and the district court found that there was none. This was never about damage to their property. They didn't provide any damage to their property. And there was, in 2022, when there was the project to put in a solar farm, at that point in time, Lynn County looked into this in the Board of Supervisors, and they made sure that there would be an agricultural mitigation plan and a drainage plan. And as part of that, what happened is that SIPCO was required to look into that. They hired a drainage engineer, someone chosen by the Robinsons, and that drainage engineer did what's been talked about here. They designed a system that would take the water efficiently down to Heaton's Creek as it had been for decades. And that was Mr. Edler, and Brandenburg did the installation. And when we asked in this case, during the course of depositions, is there any indication that this system isn't working, Mr. Robinson testified it's inconclusive. The tenant that farms the Robinson land testified it's a Cadillac fix. precisely what can be done here. We do have drainage engineers. There is nothing in the state of Iowa that requires that you lay the drainage pipe in a particular path on the survey and estate. In fact, Logston says just the opposite.
Your opposing counsel's argument that despite the dispute about the quality or the effectiveness of this drainage system, they have documented losses in crop yield since the time this has been rerouted. Is that a correct statement? And if it is, what is your response to that, and why isn't there a fact issue?
Correct, Your Honor. Here's what the finding was from the district court. The district court found that in order to prove damages in a case like this for crop loss, what you need to establish is either what's the value of the crop in place currently, or what would it take to take it all the way to maturity minus the cost. None of that was in the record. Also, you need to establish what is the general damage to the crop from general surface water that happens on all cropland in Iowa. None of that was established. But the biggest issue with damages in this case was this. In order to claim loss to crop yield, you have to establish what the base yield is. What is the yield on this land typically before the alleged incident, before the alleged drainage or backup? There was no evidence of that offered at all. And that's one of the reasons that the district court said, we don't have anything here on which to award damages.
Robinson testify on the stand that he did have a reduced yield in the 1 year where he analyzed it. Is that enough?
Not enough because it doesn't establish the base yield for the farmland. What he did is he concluded in 2021, which is the only year he looked at. What he said is there's some acres that were affected. He characterized the acreage as a swag. 35 acres, but 35 acres is a swag. So we have speculation right there about how many acres were affected. And then he testified that there were 50 bushels per acre, I believe was the testimony that was lost, but no baseline yield.
Arguments more to credibility for a jury to determine. It seems like our case law recognizes that once damages are established, they can't be speculative, but they also don't have to be to a certain level of specificity either.
Your Honor, we would submit that when a litigant merely states the conclusion, I've been damaged to 50 bushels per acre, that's a conclusion, but that's not evidence of loss. And we recognize there's a difference between proof of loss and the measure of that loss. But here in this case, we think this is one of those rare cases where we don't have the proof of loss because we don't have any base yield on which to compare this to. We don't know, for example, if typically in this part of the farm, what is the typical yield?
I mean, are we talking about just, all that's missing is if he had said something like, I used to get 200 bushels an acre, and now I get 150 bushels an acre. If that would have been enough?
That would have been sufficient if that would have come into evidence, and it just didn't. And here was the issue with the evidence, another component of this. There are yield maps for every year. They weren't even looked at for 2014 through 2020. Those would have established a base yield for this cropland. They weren't consulted. 1 year was looked at, and there was just an estimate as to how much was lost. No comparison. This was such a significant issue in this case for the Robinsons that they hurriedly went to look for something else that they could rely upon to establish the base yield. That's why they took some YouTube screen grabs, submitted those late, and the district court said, wait a minute, that's inadmissible hearsay, that's beyond the
Dispute in the case, the motion to compel, was it related to this issue?
On this issue, the dispute was simply, we asked for the basis for the damage claim. It wasn't forthcoming, moved for partial summary judgment on that issue, and then we get a late produced, again, YouTube hearsay screen grabs that attempt to establish that here is the here's how much you may lose when you have a drainage issue on your property. And the court said that was late produced.
Attorney fee issue before your time expires. So the basis for the award was under the quiet title piece, correct? So how does Coggin do an attorney fee? They're not the landholder. They didn't file a counterclaim for quiet title.
That was filed by both entities at a time when quieting title would have affected both parties because of the planned solar farm construction. But you're correct, Your Honor, that the land is SIPCO's land. The total amount awarded in this case is the amount that was expended in order to attempt to quiet title to that statute. But it is correct that that is SIPCO's land, not Coggin Solar's. And I do have saved some time for Mr. Moreland for his clients, the Ludoffs.
May it please the court, counsel. My name is Joe Moreland, and I represent Ken and Denise Ludoff. They were the original owners of where the substation is located in the 5 acres owned by SIPCO. They're the only neighbors that are participating in the solar project that have been sued, and they own the land immediately south of where the tile goes off the SIPCO property and onto the Ludoff property. And I'm here because the limited claims filed against Ken and Denise, which really had to do with a right to enter and repair that the Robinsons are claiming on the Ludoff property. The Ludoffs do not want anyone assessing their farm ground without specific permission. And they don't want anyone accessing their farm ground to repair damaged tiles. If tiles need to be repaired on the Ludoff property, they will do so.
Record about who actually put those tiles in or who owns them?
The record indicated that they were there before the Robinsons purchased the property, and both the Ludoff parents and the Robinsons parents lived on these farms. These are generational farms, and so the record wasn't exactly clear who installed them, but the record was very specific that nobody during the time that Ken and Denise had owned this property or their Ken's recollection of his parents owning the property, did the Robinsons ever access the Ludoff property to make any repairs or do anything regarding this tile line, okay? So the two claims that were made against the Ludoffs that the district court dismissed had to do with prescriptive easement, and then a common law right they claim exists for access when a right-of-way, or excuse me, a waterway easement exists. And the district court found that neither one of these applied and dismissed them on summary judgment. We would request that the court uphold that ruling, and we believe that, excuse me, I got, my time's up, kind of a few more minutes. Yeah. The Countryman case, which is more akin to the facts of this case, right, where there's no other easement rights other than the natural flow easement, the natural waterway easement, and in that case, the plaintiffs requested an injunction that was in fact granted, right? And so there needs to be some procedural requirement rather than just somebody who thinks that tile needs to be repaired accessing their neighbor's property. So I just think from a practical matter, what the Robinsons have relied upon for what they try to justify right and access to my client's property just doesn't exist under the common law. Thank you so much.
To Mr. Geerdes.
Thank you. A few follow-ups on the evidence regarding crop damage. First, it's not just Marty Robinson's testimony. That testimony was based on a yield map. That gets us back to the discovery issue. The trial court issued an order requiring us to provide discovery within a certain time period, and we did that. And obviously, the maps, the yield maps, and the crop yield issue were discussed at the deposition. So the
Maps part of the summary judgment record?
I don't know is the answer right now. I know that the testimony of Marty Robinson is, And I know that the 2021 yield map was extensively discussed at the deposition. Whether or not the maps were actually introduced as part of the record in the appendix.
The drain diverted, or
I'm in 2014.
in the record about the yield from 2014 forward?
Is the testimony of the tenant, who, Mr. Price, who SIPCO admits was repeatedly going to SIPCO and saying, hey, this farm is not draining properly. There is land which is accumulating water in the southeast corner of it.
Record about the specific crop yields from 2014 forward for each crop year.
2021, I know that
Is there evidence in this record about the specific crop yield for each crop year from 2014 going forward?
other than 2021, no, I don't believe so. What we have, because we don't have those yield maps, what we have is the testimony of Tom Robinson, who says that the crop in that portion of the farm looked sick, was pale, was yellow. We've got the testimony of the farm tenant, who says that this just isn't draining right, there's ponding water. Underneath Iowa's liberal rule for crop damages, we do not need to show the precise drop in yield, and it's not speculative once we've shown that damage has existed, and we've shown that.
If it only happened in 2021, why should there be any inference that that's caused by the drainage system? It seems like it would be a persistent problem and not a one-year problem.
We know that there's been crop damage since 2014 because Mr. Etler's engineering report shows that, the farm tenant shows that, and Tom Robinson's testimony shows that. So we know that the damage has existed, and that means that it's a question for the trier of fact. Now, some other issues. First, the legislature uses the language in the statute, general course of natural drainage. It seems to me that the legislature has chosen those words for a reason, and if we want to make an exception to that, it should be up to the legislature to decide what the exception should be. Secondly, the case cited by opposing counsel is not applicable for two reasons. One, it did not involve the destruction of an existing tile, and therefore about a case which I don't remember the name, but it's the case involving the altered course of a drain, which somebody didn't like. And what that case tells us is that the statutory language did not come into play because there was no destruction of a tile, and there was no damage to the uphill tenant. Lastly,
Tile is put in, it's there forever.
once a tile has been put in, then you could do what the Wasserman case does, which is the Ohio case on which they rely. And in that case, the downhill tenant entered into a contract with the uphill tenant, which gave the downhill tenant the right to relocate the tile.
Was that expected to be how it would be handled? That anytime that tile has to be changed, you have to enter into contracts? Do you really think that's an interpretation of it?
Because when you take tile out of the natural water course, you are inviting trouble. And you should not have to, as an uphill tenant, count on the good graces of your downhill tenant to make it right. That's what happened in this case in 2014, and it was a disaster. We've got the better part of 10 years of impaired crops because there was not an adequate drainage for the Robinson property.
Structure of chapter 468. So part of your argument relies on 468, 148, and 149 regarding the diversion of water, but that's in Division 1, which relates to drainage districts, if I understand that correctly.
Yes. Oh, well, no, it's not, because in the McEwen case, you ruled and held that the statutory provisions of the chapter applied to private tile and not just drainage districts. And there's been...
It's structured, that is in kind of drainage district section, and Division 5 deals, or Division 5, I think, deals with individual drainage rights.
No, I think that the provisions of the chapter that are applicable to tile apply to both public tile and private tile. And I would also encourage you, I don't have the site in front of me, but there's been a reorganization of Iowa drainage laws. And when you look at the legislative history of that reorganization, you will see that there was a specific provision in there stating that that reorganization was not intended to change anything. It was not intended to make any difference. The legislature is very protective of drainage rights.
Questions by the bench? Okay, thank you, sir. Robinson versus Sipco and Ludos is hereby submitted, and we'll have a brief pause before we have our next case, which is in the matter of the property seized for forfeiture from Bitcoin operating.